I've just got my.
Hey, I'd like to welcome all of you today, the 21st of November, to our next Toolbox webinar. Today may become an auspicious day. Later on in the afternoon, we're going to have an update from the federal government, and maybe there'll be tax cuts, but I don't think so. Probably just more complications. Today, we've got an eclectic mix of topics, looking at some tax and non-tax issues across the firm, which we thought would be of interest and relevance for today. We're going to start with post-mortem tax planning. Greg Ferrano, one of our senior tax partners, very experienced in this area, has found so many situations where there are traps for the unwary and different methods one can choose for how to deal with post-mortem tax planning. So he'll give us a brief on that. And I should mention all of the presentations are put into either PowerPoint or Word format, which will be uploaded onto our website for reviewing later, including Greg's hot topic. And then the next presentation is on the competition law area of our practice, wage fixing and no poach provisions. You may recall during the pandemic, there were bonuses and then the bonuses stopped. And so the government has brought in new legislation to prohibit fixing and controlling wages. Unusual, more often we see prices, but this is a new and interesting topic where we're going to hear from a team of Ken Jewell, Catherine Karskowen, and Lee Stratton, who've been working on the presentation. And then the next one, we are finding more and more organizations that have been set up for social purposes, such as golf clubs and so on. And they find that when the old legislation, whether it's federal or provincial, is updated to new not-for-profit legislation, they have to make significant changes. And we have to be wary of tax implications and what they want to accomplish. If they don't do it on a timely basis, they could find themselves in big trouble and dissolve. And the final presentation, and that is going to be by Heather Keachy and Cliff Goldfarb, two of our experts in the social corporate sphere. And our final presentation is by Ian Spiegel, our tax associate, who will talk about a foundational case now on the general anti-avoidance rule, Dean's Night, which is a hot topic for us tax practitioners. And I hope it'll be of interest to the group. So let's start with Greg and talking about post-mortem tax planning. Greg, over to you.
Thank you, Lauren. There we go. Anyone seen The Office? Yes. I understand that's Dwight. Welcome, everyone, and thank you for joining today. I received a minute book yesterday from my client, gave it to Ian immediately. A new client referred by an accountant, the shares of which were owned by an individual we'll call Mr. Smith. Mr. Smith passed away in January of this year, and the lawyer who was responsible for maintaining the minute book dutifully prepared transmission documents to transmit Mr. Smith's shares to his two sons, the beneficiaries under his wills. Unfortunately, by doing so, the lawyer may have eliminated one of the options for reducing the incidence of double tax arising as a result of the fact that Mr. Smith was deemed to dispose of his shares of his company, which I'll call Invesco, at fair market value on his passing in January of this year. In Canada, individual taxpayers are deemed to dispose of capital property at fair market value at death, and as a result, their estates pay tax on the resulting capital gain. At the highest marginal rate in Ontario, the tax is 26.76% of the capital gain. The double tax issue can be best illustrated by an example. Mr. Smith in 2000 purchases shares of Invesco or subscribes for shares for $1,000. Invesco takes that $1,000 and purchases shares of Techco. Techco does spectacularly well. And in 2023, the shares of Techco are worth $1 million. Mr. Smith's shares of Invesco are also worth $1 million, representing by the increase in value of the Techco shares, and where Invesco has no assets or liabilities other than its shares of Techco. On Mr. Smith's passing, he is deemed to dispose of his shares of Invesco for $1 million and realizes a $990,000 capital gain. And his estate will have to pay tax on that gain of, at the highest marginal rate, 26.76%. Having said this, the shares of Techco owned by Invesco are, the cost of those shares are not increased as a result of the capital gain realized by Mr. Smith on his death. So when Invesco turns later to sell the shares of Techco, it will realize a second capital gain of $990,000, and it will have to pay tax on that gain, the same economic gain that Mr. Smith paid tax on in his final year. Lastly, when Invesco distributes the after-tax proceeds of the sale of the Techco shares, the estate or Mr. Smith's beneficiaries will pay a third layer of tax on the taxable portion of the deemed dividend, the dividend resulting. There are three methods for reducing this incidence of double tax. One is called the subsection 164(6) loss carryback. The second is commonly called a postmortem pipeline. And the third is the Section 88 bump. The loss carryback results or replaces the capital gain realized by or deemed to be realized by Mr. Smith in his final year with a dividend in the first year of Mr. Smith's estate. It is implemented by Invesco redeeming the estate shares, the estate being deemed to receive a dividend equal to the redemption price of the shares less their paid up capital, the estate realizing a capital loss on the disposition of the shares, and Mr. Smith's estate electing to carry back that loss to Mr. Smith's final year and applying the loss against the capital gain, which Mr. Smith was deemed to realize on the deemed disposition of his shares. The loss carryback must be completed within 12 months of Mr. Smith's death and may only be completed to the extent that his estate is a graduated rate estate. Now, by implementing the 164(6) loss carryback, the estate is substituting a dividend for a capital gain. The tax rates on dividends in Ontario are significantly higher than the tax rates on capital gains. The tax rate on an eligible dividend, to the extent that Invesco has a general rate income pool balance, is 39.3%, and the tax rate on other than eligible dividends is 47.7%. So why would an estate choose to substitute a higher tax dividend for a lower tax capital gain? Well, generally speaking, it would not. And it would implement a 164(6) loss carryback only where it has tax attributes such as a capital dividend account balance and an RDTOH balance that reduces the effective tax rate of the deemed dividend. It would also implement a 164(6) loss carryback where the trustees or the beneficiaries of the estate wish to wind up Invesco shortly after Mr. Smith's death, or where the CRA administrative requirements for a postmortem pipeline, which I'll discuss in a minute, cannot be met. There are various stop loss rules which we must consider when implementing a 164.6 loss carryback. The first, in subsection 40 sub 3.6 of the Income Tax Act, is not a concern in Mr. Smith's estate's case, where there's an exemption from the loss denial rule in that subsection, where Mr. Smith's estate will be a graduated rate estate and will carry back the loss under 164.6 to Mr. Smith's final year. The second stop loss rule is what we call a loss grind rule, and it will grind down the loss if the deemed, or if an excessive portion of the deemed dividend realized by the estate on the redemption of its shares by Invesco is elected to be a capital dividend. And the loss is ground down by an amount which is 1/2 of the lesser of the loss on the redemption of the shares, in our case, $990,000, and the capital gain realized by Mr. Smith on his death, also $990,000. The loss grind is avoided by limiting the capital dividend on the deemed dividend to 50% of the dividend, which is called the 50% rule. The second method for reducing the incidence of double tax is called the postmortem pipeline. It preserves the capital gain in Mr. Smith's final year, but it facilitates the estate's ability to extract the value of Mr. Smith's shares tax-free after Mr. Smith passes away. It's implemented by the estate incorporating a new company we'll call NewCo, transferring its shares of Invesco to NewCo, and in NewCo satisfying the transfer with a promissory note, which can then be repaid or paid tax-free by Invesco to the estate. In our example, Mr. Smith's estate transfers the shares of Invesco, which it owns, to a newly incorporated company and takes back $1 million promissory note. It preserves the $990,000 capital gain in Mr. Smith's final year, which is taxed at 27.76%. It can also be combined with a Section 88 bump, which I'll describe in a few minutes. There are several rules which we must consider when implementing a postmortem pipeline. One is an anti-stripping rule in Section 84.1 of the Income Tax Act, and the second is a deemed dividend rule in subsection 84 sub 2. The CRA has ruled that it will apply these two rules to a postmortem pipeline unless certain requirements are met. One, Invesco must carry on a business or an investing activity at the time of the transfer of the estate shares to NewCo, and must continue to carry on that business or those investing activities for at least 1 year after the transfer. Invesco can't be wound up or amalgamated into NewCo for at least 1 year. The amount of the promissory note issued by NewCo to the estate cannot exceed what we call the arm's length adjusted cost base of the shares, the estate shares of Invesco. And effectively, Invesco's assets, being the shares of TechCo, cannot be sold for at least 1 year following the transfer of the shares into Invesco. So the postmortem pipeline takes some time, where the 164.6 loss carryback can be implemented immediately following Mr. Smith's passing. The postmortem pipeline takes about 2 or 3 years to implement. It also involves the incorporation of a company. The Section 88 bump can be implemented in conjunction with a pipeline. It results in an increase in the cost of the non-depreciable capital property owned by Invesco, in our example, the TechCo shares. So by implementing a bump, Invesco could increase the cost of the TechCo shares from $1,000, excuse me, to $1 million, thereby eliminating the second layer of tax that we discussed earlier. Again, the Section 80 bump is implemented in exactly the same way as a pipeline. The estate incorporates a company, NewCo, transfers its shares of Invesco into NewCo, and then NewCo is either wound up or amalgamated into, Invesco is amalgamated or wound up into NewCo. NewCo then elects in its tax return to increase the cost of the TechCo shares to $1 million. The bump, like the pipeline, preserves the capital gain in Mr. Smith's final year, and again, can be combined with a postmortem pipeline. So choosing between the three methods, an estate would generally not choose to substitute a taxable dividend for a capital gain, where the tax rate on dividends is significantly higher than the tax rate on capital gains. It would choose to do so where it can reduce the effective tax rate on the dividend by using a corporation's capital dividend account balance or a refundable dividend tax on hand balance, or where it can generate those two balances by transferring assets, for example, the shares of TechCo, to an affiliated corporation, triggering a capital gain, which generates a capital dividend account in Invesco and refundable dividend tax on hand in Invesco. Transferring the shares to an affiliated corporation will also bump the cost of the TechCo shares in the same way as a Section 88 bump would. As I mentioned, an estate might choose to implement a 164(6) loss carryback, notwithstanding that dividends are taxed at a higher tax rate than capital gains, where the trustees of the beneficiaries wish to wind up Invesco quickly after Mr. Smith's death and don't want to wait around the 2 or 3 years that it takes to implement a postmortem pipeline. Also, the trustees may choose to implement a 164(6) loss carryback, where they cannot otherwise meet the requirements or CRA's administrative requirements for implementing a postmortem pipeline, which would include where Invesco holds only cash or near cash liquid assets and has no business or carries on no investment activity at the transfer of the shares by Mr. Smith's estate to NewCo. Again, a postmortem pipeline preserves the capital gain in Mr. Smith's final year, but it involves implementation costs and at least 3 years, depending on who you speak with, to complete. And again, it can be combined with a Section 88 bump. So where we are advising an estate which owns or receives shares of a private corporation, we need to be aware of the fact that, firstly, the individual deceased was deemed to dispose of those shares at fair market value and realized a capital gain as a result, and that there is double tax, which results from that deemed disposition, and that there are various methods for reducing or minimizing that double tax. But before transmitting the shares, or the Mr. Smith shares, to his beneficiaries, the advisors and the trustees should consider these methods and decide which one they wish to implement before dealing with the shares. Thank you.
Thank you, Greg. We now have a team of Catherine, Ken, and Lee to talk about competition matters.
Thank you, Lauren. I just wanted to reiterate what Lauren said. This is a team presentation. I'm going to be followed by my partner Ken Jull and then partner Catherine Carskellen, who are going to flesh out this topic. As Lauren said at the outset, we're talking about some changes to the Competition Act specifically the wage fixing and no poach provisions, which were enacted in 2022, but came into force in June, on June the 23rd of this year. And what they do is they add to the criminal provisions, the offense provisions of the Competition Act, in particular, the conspiracy provisions in Section 45 sub 1. These are the real central, I realize that I'm not pressing these slides forward, so let's just try this. Sorry, forgive me, and I'll return to my comments. There we go. These two provisions are at the core of the offenses provision of the Competition Act. And Section 45 1.1 prohibits agreements between unaffiliated employers to fix or control wages or other terms of employment, or to not solicit or hire each other's employees. As Lauren mentioned when he introduced the topic, these provisions came about because of some things that happened during the COVID period. And I just want to mention that the offenses provision, or the offenses part rather, of the Competition Act contains other types of offenses. The most notable probably is bid rigging. But it has some curious other provisions, one of which is false or misleading representations given in electronic messages. One wonders, what's that about? Well, what it was about, what triggered that was elderly people being preyed upon by electronic marketers. So the Competition Act was amended with that provision to protect a vulnerable group. And essentially, that's what the Competition Bureau brought forward with the wage fixing and no poach provisions of the Competition Act. It was felt that employees were getting a raw deal, and so these provisions came forward. You may remember that when the pandemic set in and we had lockdowns and such, a number of ordinary workers, warehouse people, shopping store attendants, were given significant raises. And an incident that really prompted this was all of a sudden, somewhat after the initial lockdown, all of the big shopping store chains, grocery store chains in particular, seemed to sort of put a cap on and reverse the increases that they had extended to their workers. And a lot of people felt this was wrong and bad, and that there were vulnerable employees who needed some help. And so the Competition Bureau stepped into that breach, and this legislation was proposed, enacted in 2022, and brought into force earlier this year. I should say that this legislation impacts more than the people who I think were of concern initially, but that's the context. And part of the interesting exercise in this legislative change is, why was it enacted in 2022 but not brought into force until 2023? Well, part of it was to make sure that the law-abiding public became aware of these provisions, and to that end, the Competition Bureau did a bunch of awareness-raising exercises, and they prepared and released, and I believe it was February of this year, draft enforcement guidelines for wage fixing and no poaching agreements. And those draft enforcement guidelines were the subject of a lot of comment and scrutiny and comment, and they were followed by the final form of the enforcement guidelines for wage fixing and no poaching agreements on the 30th of May, like a couple of weeks before the legislation came into force. And again, the Bureau wanted to articulate some of the reasons for this change in the legislation. They wanted to protect competition in labor markets. That sounds pretty grand. And they wanted to prohibit agreements between employers to fix wages and restrict job mobility. So, as I say, these sound like very grand and important policy initiatives by the government. Let's look at the legislation. Section 45, subsection 1.1 is the key to this provision, and it provides that every person who's an employer commits an offense who, with another employer who's not affiliated with that person, conspires, agrees, or arranges to fix, maintain, decrease, or control salaries, wages, or terms and conditions of employment, or to not solicit or hire each other's employees. The enforcement guidelines have expanded on this, this bald text, and they've made clear that these provisions only apply to agreements entered into on or after June 23rd of this year, or to agreements that have provisions which did violate the statute, which are reaffirmed or acted upon after June the 23rd. If you've got an agreement that has one of these offensive provisions, but you don't do anything about it, forgive me. If you have an agreement that was entered into before June 23rd of this year, and you don't do anything about it and you don't act on it, then it's fine. After the 23rd, on or after the 23rd, that's a problem. As noted, the provisions extend to unaffiliated employers, and it's regardless of whether they compete or not. These provisions are per se illegal, and that's important for employers, for a lot of businesses who might have these kinds of protective agreements for their wage earners and their employees. There are a couple of other key terms in the legislation. Employers is one. It's, according to the Competition Bureau, to be interpreted very broadly to include directors, officers, agents, or employers, or agents or employees such as HR professionals who are considered to be senior officers who are entering into these agreements. The term employee, interestingly, is not defined in the Act, and we expect that that will be the subject of a lot of jurisprudence. But I think we can say fairly confidently that independent contractors are not employees, and so that may be a planning approach that can be taken by employers or businesses, and also unions and unionized employees are not considered employees, and there's a big exemption, which I think Catherine will be talking about a little later in this presentation. Let's get a little bit more granular about what 45.1.1 deals with. Specifically, there's a concern about controlling terms or conditions of employment, and the government has expounded on that, as noted in this slide that's currently up. But it's important to note that what the Competition Bureau has said is that whether terms and conditions set will be subject to consideration for prosecution really depends on whether it is having an impact on employees and whether in fact it has a wage impact on employees in particular. It should be said, though, that the guidelines do not bind the Competition Bureau, nor do they bind the Department of Public Prosecutions, which would take these cases should they arise. On the issue of the no poaching agreements, the enforcement guidelines notes that only reciprocal agreements not to poach each other's employees will be prosecuted. One-way agreements are noted to be exempt from this treatment. What is a one-way agreement? one-way agreement is essentially an agreement which is imposed on an employer. So for example, an owner of a building that's being constructed may impose on its various contractors not to poach from the other contractors. That's a one-way agreement. I think that there's some uncertainty as to whether that is truly a one-way agreement, because obviously the contractors are agreeing to be bound by these terms. So there is an element of reciprocity there, but that's the general concept. We should talk about how serious this is. As I said, the conspiracy provisions and these wage fixing and no poach agreement provisions of the Act are very serious, and they can be subject to punishment by imprisonment or a fine or both. And the imprisonment can go up to 14 years. I don't think there are a lot of cases where that happens. But note that the fine has no monetary limit. I think that's where there is going to be something very interesting happen over the next several years. There's absolutely no cap to that fine. It's not 10,000 max or even 100,000. It's like the sky's the limit. So we'll have to see where that goes. But these are very serious offenses, and I suspect they will be prosecuted very strenuously by the government. Finally, I just want to say a little bit more to underscore that this is a criminal provision, and 45 sub 3 makes that very, very clear and articulates the criminal standard of proof that these offenses must be proved beyond a reasonable doubt. They're not civil offenses. So there's a high onus on the government to prove these offenses. I think Ken is going to talk about an area where that gets mixed up a little bit when he talks about ancillary restraints in a moment. But these are criminal provisions, and they can be proved by circumstantial evidence, and there doesn't need to be evidence of direct evidence of communication between the parties. These are per se illegal agreements, and if there's some evidence that there's been some conspiracy here or agreement, then that's going to be sufficient for the government to take action. Ken's going to now talk about the ancillary restraints defense.
Thanks, Lee. When I was at the Bureau on an interchange in the position of general counsel with the Competition Bureau Legal Services, we did not have these provisions. I have stayed in touch with my ex-colleagues, and I've had lots of debate with them about these provisions. And what I wanted to talk to you about today is the ancillary it's been commonly called the ancillary restraints defense. And so it's set out in section 45 sub 4, no person shall be convicted of an offense under this section in respect of a conspiracy, agreement, or arrangement that would otherwise contravene the subsection if A, that person establishes on a balance of probabilities, we'll just park that for a minute, we're going to come back to that, that it is ancillary to a broader or separate agreement or arrangement that includes the same parties and is directly related to and reasonably necessary for giving effect to the objective of that broader or separate agreement or arrangement. Okay, what does all that mean? Well, from a substantive point of view, what it's really in effect saying is we're going to allow and accept that there will be discussions about wages between affiliated parties that are ancillary to a broader agreement, and the Bureau has released, as Lee mentioned, guidelines that set out what those type of arrangements are. So in principle, there's some flexibility. And the difficulty is in the details, and the guidelines have been criticized by the Canadian Bar Association. They are not terribly clear. And so this is an area that is prone to some difficulty in terms of going forward. We don't exactly know what will qualify and what won't. And as Lee said, what is of concern is that we are dealing with criminal legislation. I'm much less concerned with an administrative monetary penalty if there's some uncertainty. I'm a lot more worried about advising clients where the downside is criminal liability. So there's a real concern here. But what I really want to talk to you about today is something I'm more concerned about. I think, and I've told this to my former colleagues at the Bureau, I think this section is unconstitutional. I think it can be struck down. And I may be one of the people that leads that charge. Why do I think it's unconstitutional? Because what this section does is it puts the onus on you, the proponent, the industry. You have to establish on a balance of probabilities. You've got the legal onus of establishing on a balance of probabilities that this scheme is ancillary and is reasonably necessary to accomplish that. So let's just step back a little bit and talk about criminal law for a moment. If Ian and I got into a fight, highly unlikely, but if we got into a fight and I struck Ian and I said I acted in self-defense because he came at me. We got into a fight about whether the Cleveland Browns really are the best team in the NFL. I would go to a trial and I would say, look, I acted in self-defense. Now, here's the key. I do not have the legal onus to prove on a balance of probabilities that I acted with self-defense. I can say I acted with self-defense because he was raising his fist. The prosecution in a criminal case must prove beyond a reasonable doubt that I did not act with self-defense. That onus in a true criminal case never shifts to the defense. It always stays on the Crown. I have to raise some evidence. I have to show there's an air of reality. I have to show I really feared Ian, right? But at the end of the day, the legal onus rests on the prosecution to prove that I did not act with self-defense. This is different. This is saying, no. The prosecution doesn't have to prove beyond a reasonable doubt that you did not have an ancillary purpose or that there wasn't a reasonable cause for the scheme. You have the legal onus. You as the defendant. And this is very unusual in criminal law, and I say unconstitutional. So what's my argument for that? There is a parallel in corporate criminal liability, which I've written about, that requires that a corporation take all reasonable measures. But even there, all reasonable measures to prevent, for example, criminal negligence or bribery or corruption. Even there, the legal onus has not been shifted. It's still on the onus, is on the prosecution to prove beyond a reasonable doubt that there was a failure by the corporation to take those reasonable measures. But even there, the onus doesn't shift. So where in law does the onus shift? Well, there is some precedent in Canadian law for that in strict liability offenses. Now, I have to take a pause and remind you of what a strict liability offense is. Even when I teach this at the law school, I expect my students to know what a strict liability offense is because they're second and third year, they've taken first year. And I always say, how many people know what a strict liability offense is? And most of them confess that they weren't paying that much attention and they don't remember. So let me just remind you, what is a strict liability offense? It's a halfway house. It's been described as a halfway house, a regulatory offense. And the halfway house is for offenses like pollution, environmental pollution, for occupational health and safety, for example. These are strict liability offenses. They're not true criminal offenses. They tend to be enforced provincially, but there can be federal regulatory offenses. And as set out in the Supreme Court of Canada in the case of Sault Ste. Marie, for those regulatory offenses, the legal onus is on the defense on a balance of probabilities. Okay, so how is that different than criminal law? Supreme Court of Canada in the case of wholesale travel said prima facie, reversing legal onus does violate section 11D of the Charter, presumption of innocence. So the starting point is prima facie, reversing legal onus is offside. However, in regulatory offenses, it was saved under section 1 of the Charter. The Charter, as you recall, has this section which allows a court to say, even though it is offside, it's saved as reasonably and necessary under section 1. And how they did it in wholesale travel, which dealt with misleading advertising, was they said the following, and I've highlighted it in red. It cannot be said that the stigma associated with this offense is analogous to the stigma of dishonesty, which attaches to a conviction for theft. And so in plain language, what they were saying is this, and I'm going to paraphrase, but when I teach this to my students, I always say, imagine you're at a party and you have to confess that you committed an offense of some sort. You know, if you had to confess that you committed theft or fraud, that's serious. Most people at the party say, nice to know you, I've got to see somebody over there I'd like to talk to, right? Mm-hmm. If you had to confess that I committed the regulatory offense of deceptive marketing, I committed the regulatory offense of failing to take reasonable measures to prevent something from occurring in a regulated workplace. The court's saying that has much less stigma. It's just not, it doesn't have the high level of stigma that attaches to a true criminal case where you could go to jail. Although you could potentially go to jail for misleading advertising, but these are the words of the Supreme Court of Canada. Okay, that's what saved the regulatory offense. So you've got low stigma for the misleading advertising, which allows the the offense to survive. Now, let's jump ahead to wage fixing or price fixing. I say, and this is my constitutional argument, my lords, I say wage or price fixing has high stigma. It is tantamount to fraud. If you're at that party and you say, so I got convicted of price fixing, everybody thinks that's bad. That's Loblaws. Didn't Loblaws get convicted of that? Didn't they? Well, they didn't get convicted. They admitted they did it and they got immunity. Canada Bread, however, got convicted. And let's talk about that because there's some wording in Canada Bread that supports my constitutional argument. Canada Bread recently agreed in a court that it fixed the price of bread. And in the decision approving that plea and sentencing Canada Bread to pay a $50 million penalty, the court said the following: the offenses in this case were extremely serious. Price fixing was aptly described in R versus Maxone as analogous to fraud and theft. Therefore, I say, ladies and gentlemen of the jury, the court has clearly spoken. Price fixing is analogous to fraud or theft. And if I'm right, and I think I am, that means there's high stigma. And if I'm right on that, then that means I don't think it's going to survive a constitutional challenge because it's different, much different from the low stigma that attaches to misleading advertising. And therefore, in my respectful view, not shared by my former colleagues at the Bureau, who think, well, if you want to rely on this, you have to prove it. I think they're wrong. I think this is unconstitutional. I think it will be struck down. It's just, you don't want to be the company that has to go through that. But as I said, I believe it's unconstitutional. I think that gives some leverage in the future. So I'll turn it over to Catherine.
Okay, I was just going to speak a little bit more about the enforcement guidelines and in particular, some of the defenses that are available. The enforcement guidelines were provided by the Bureau as part of their commitment to transparency and predictability. And while they do provide some guidance, including examples and explanations, they do allow the Bureau broad enforcement discretion. And as my colleagues noted, a lot of uncertainty remains. As Ken and Lee indicated, to be eligible for the ancillary restraints defense, the restraint has to be ancillary to a broader or separate legitimate agreement, including the same parties, and the restraint must be directly related and reasonably necessary to give effect to that broader agreement. So the guidelines indicate some of the factors that the Bureau will take into account in determining if a restraint is reasonably necessary. They can look at the terms of the agreement, and they'll consider whether the parties could have achieved an equivalent or comparable arrangement through practical and significantly less restrictive means. In particular, they'll look at the duration, subject matter, and geographic scope of the restraint, including whether it applies to employees who are unrelated to the collaboration, and whether in absence of the restraint, the agreement or arrangement could only be implemented under more uncertain conditions or at substantially higher cost or over a significantly longer period. They'll also look at what led to the adoption of the restraint, including evidence during the negotiation of the agreement, demonstrating the objectives, evidence of any alternative options considered, and any submissions, of course, that the parties make to the Bureau. In the enforcement guidelines, the Bureau does recognize that reasonably necessary restraints can play an important role in business, in protecting parties' business interests. And they state that as a general rule, they will not assess the wage fixing or no poaching clauses that are ancillary to merger transactions, joint ventures, or strategic alliances under these provisions. The guidelines do describe what a strategic alliance means. Whether in its exclusive definition or not is unclear, but they refer to strategic alliances as being those that permit firms to combine capabilities and resources so as to lower the cost of production, enhance product quality, and reduce the time required to bring products to market. The guidelines also importantly state that the Bureau recognizes that these types of restraints can play a role in many business arrangements, such as franchise agreements and certain service provider client agreements, including staffing or IT service contracts. However, the Bureau may start an investigation under these provisions if the restraints are clearly broader than necessary in terms of duration or affected employees, or where the agreement or arrangement is clearly a sham. So it's not clear really from those guidelines in that statement whether the Bureau will presumptively consider that those agreements will not be subject to scrutiny under section 45(1.1), or if they would normally qualify for protection under the ARD. And they don't provide any clear guidance in terms of the appropriate duration of a no poach clause or the employees to which it applies. Although perhaps could be read into some of their comments that they'll consider it reasonable only if you target the employees who are involved in the actual collaboration as opposed to all employees of a party. One of their hypothetical examples in the guidelines references a no poach clause that expires contemporaneously with the broader agreement, but they don't make any comment as to the reasonableness of a no poach clause that might extend beyond the term of the agreement. It's important to note as well that even if the ancillary restraints defense applies, the Bureau may still examine the agreement under the reviewable matters provisions of the Act, including the civil agreements provision in section 90.1, in which case the Bureau then has to demonstrate on a balance of probabilities that the agreement results in a substantial lessening or prevention of competition, or is likely to do so. We thought it might be helpful to provide a quick fact scenario. And this was an arrangement or scenario that I came across with a client a couple months ago. They were party to a pre-June 23rd services agreement. They were a small mid-sized service provider who embedded employees with a much larger organization. And their agreement was up for renewal. In looking at it, it contained reciprocal, non-solicit, no hire covenants and other restrictions regarding reassignment of the service provider's key employees. And so the concern was that renewal by the parties of the agreement could be construed as conduct that reaffirmed the agreement, including the restraints that contravened the provisions of 45.1.1. So considerations that were discussed was removing the reciprocal offending covenants altogether, trying to make them one way, but the service provider clearly was in a position of less bargaining power. There was a clear imbalance of bargaining power. Certainly review the restrictions in terms of duration and scope and make sure they were reasonable. And try to establish evidence if they were comfortable relying on the ancillary restraints defense. But that still seemed risky and uncertain, given the lack of clarity in the guidance, the potential significant penalties, and the fact that in face of an investigation, the onus would be on the employers to provide evidence that their agreement fell within the scope of the defense. A couple other exemptions and defenses to mention. Section 4 of the Act contains an exemption for agreements between employers with respect of collective bargaining with their employees over salaries, wages, or terms and conditions of employment. And there's also a defense in the Act for what's called the regulated conduct defense. So that's a defense for conduct that is either required or authorized by another federal act or provincial act that allows such conduct. A couple other considerations to keep in mind, in addition to the potential criminal liability, there's potentially exposure to civil actions by private parties, either on an individual or a class basis for damages. Potentially, for some parties, debarment or disqualification for public contracts under either the federal or provincial integrity regimes. And of course, there's always the potential for reputational harm or damage if faced with an investigation or prosecution. So finally, just a few quick takeaways that parties should review commercial agreements, both pre and post June 23rd, with a view to whether or not they contain provisions that might offend this section. Provide appropriate awareness training to personnel who are involved in negotiating agreements. Make sure they're aware and familiar with the new offenses. They may want to update internal policies that are related to these practices. And if review and reassess procedures for sharing commercially sensitive information with or receiving commercially sensitive information from other employers to the extent that's applicable, so as not to run afoul of these provisions. We can stop there and.
Yeah. Thank you, Catherine. Now it's over to Heather.
The participants are on the camera.
Thanks. Hi all. Heather Ketchy. I am the co-chair of the Charities and Not-for-Profit Law Department at GR, and I'm going to take this in a slightly different direction here. We're going to talk about social clubs with share capital options for continuing. Disclaimer. So what are we talking about today? Many of you will have heard already, some of you from me, that there's new legislation in Ontario dealing with not-for-profit corporations, the Ontario Not-for-Profit Corporations Act, and non-share capital corporations in Ontario, of which there are about 60,000, need to transition and update their governing documents from what they are currently under the Corporations Act to the new Not-for-Profit Corporations Act. That is not what we are talking about today, although I'm happy to talk about that. I have a handout on that. There are a lot of corporations that still need to do those updates. There's something like 1,000 that have filed articles of amendment with the ministry out of the some 60,000 Ontario corporations. So if you or your clients are non-share capital corporations in Ontario, meaning they have members, you need to look at whether they should be doing updates to their governing documents. However, that's takeaway number one. Takeaway number two is that there actually is a separate transition or continuance regime under the Corporations Act that deals with what are called social clubs or social companies that were incorporated under the Corporations Act or a special act that also require governing document updates. And it is a totally different regime. They're incorporated under a separate part of the Corporations Act, as I just mentioned, and they are corporations that have share capital. So they have shareholders, but they have social purposes. So what are we talking about here? We're talking about your golf clubs, tennis clubs, curling clubs, any kind of social club that may have been incorporated under the Corporations Act or Special Act that has shareholders. Don't be confused. It might also have members. It could have both, but it's existing right now in Ontario under the Corporations Act. The transition regime is entirely different from the transition regime that you may or may not be familiar with respect to non-share capital corporations. So if you have a client or know of a corporation or belong to a club, and if you don't know whether this new transition or continuance requirement is going to apply, you can check the governing documents to see what statutes it's incorporated under, check to see in the financial statements whether there are in fact shareholders. If you're really unsure, you can do a public search. We can help with that. In the Ontario Business Corporations on Biz Registry system, we can actually search to see what legislation corporations are incorporated under and how it's coded. The regime, as I said, is entirely different. Non-share capital corporations, you may have heard the year 2024 bandied about, October 2024. There's 1 year left, just in case you thought there was no urgency to this, there is. However, share capital corporations or these social companies have a 5-year transition timeline. So when the Not-for-Profit Corporations Act came into effect in 2021, that started the 5-year clock for these social companies. So they have until 2026, October 2026, to complete their continuance. Unlike the non-share capital corporations, the consequences for failing to continue here are going to be significant. I think that's on my next slide, or it's at the end. If they don't continue, they will be dissolved. In addition, instead of a just transition to bring their governing documents in compliance with the new legislation, they actually have to choose a different act to continue under. So they're no longer going to be able to come in under the Corporations Act. They have to choose one of 3 options. They can continue under the Ontario Not-for-Profit Corporations Act. We're pretty familiar with that. They can continue to the Ontario Business Corporations Act, so continue as a share capital corporation, for example, or they can actually move to the Cooperative Corporations Act, which is would be a separate regime, a third option as well. If they don't make one of these choices by October 2026, they will be dissolved. So there's some time here. But if you have any clients in this position, they need to start thinking about what move they want to make fairly quickly. The continuance process itself, corporately, is similar to any other type of continuance. So you're moving from one piece of legislation to the other. You need to have a special resolution approved by the directors and 2/3 of the shareholders. Remember, these are share capital corporations, so we've got shareholder approval here. There can be some complications. Some of the social clubs that we've looked at have old legacy shareholders. So some of them have been around 50 years, even 100 years. They have complicated share capital structures. They have legacy shareholders, which have certain rights and entitlements, which have then been preserved in a separate share class. And then they have different shareholders, which have different rights and entitlements. And all of that can complicate the necessary shareholder approval that you would need in order to affect the continuance, whichever direction you want to go in. The Act right now, so you can see it's section 2.1 sub 4 of the OCA, actually requires that each class of shareholders approve the continuance, which can be a really high hurdle to overcome, since you could have a class of shareholders whose interests are not necessarily met through a continuance in one direction or the other, and having a class vote means that one particular class of shareholders effectively has a veto power over the continuance. Bob?
Sorry, I don't know if people can hear me on the.
I'll repeat the question.
I know Jennifer's here as well. You always get problems in the States where someone finds a certificate from a golf club from 1953. And what, as part of this process, do we do about these rogue shares or share certificates? Is there an easy way out, or are we stuck with some complicated exit?
So the question is, what do you do when you have rogue shareholders or estates, for example, that find share certificates from a golf club that come up some years later and basically want to cash in? The answer is there is no easy answer, and it really depends on the specific club and what the rights of those shareholders are. And this is why I'm stressing that clients need to start looking at this now, because there's no easy way to solve it. And in fact, we're not able to make amendments to the share provisions at this point. They have to just choose an option to continue. So we can't even amend to take away some of their rights. What did happen is that a selection of about 10 or 12 social clubs lobbied the government for an amendment to that specific provision in the OCA, which required class votes. And it looks like we're going to get an amendment to that to remove the shareholder class votes on continuance and make it just a general vote, which should eliminate some of that problem. We're really hopeful, because then if you've got a legacy shareholder class whose interests don't align with the remaining shareholders whose interests would be met by continuance, that legacy class no longer has a veto power over the continuance. So we're hoping that will help address that particular concern.
Heather, we can't see the slides.
That's not on me, but we're gonna get IT in right away.
Okay. That's great. Thank you.
Thanks, JB. Thanks, Lauren. There we go. I wanted to go back to this one. The other helpful legislative piece that we have is that if a social club's unable to get quorum, again, an actual problem if you've got a limited number of shareholders or legacy shareholders that whose shares were issued 100 years ago and then they've now been lost, or additional shares have not been issued, there might be an inability to actually get quorum or find the shareholders, and you have to have that in order to continue. The legislation provides right in the act that these corporations would be able to apply to the court in order to get relief from that, so long as they can show that they've made reasonable efforts to locate the shareholders and serve them with notice. We think, we have some hope based on what's in the legislation that the courts are going to assist in that by waiving the requirement. We're not entirely sure what particular order the court would give, since the discretion is within the act. It just says that the court will give an order that they deem appropriate. The rest, let's see, this is the further indications or the further list of what you need to do to continue. Continuance need to be filed and the constating documents updated, like with any kind of corporate continuance. The tricky part here is that you're actually moving from one legislation to a different legislation with different requirements. And so no matter which direction you take, the restructuring of these social clubs is going to be significant. So if you're a social club, you've got share capital, you can choose to go ONCA, but then you need to figure out how you remove the shares. You have to cancel, you have to either buy them back, reacquire them, cancel the shares, and restructure in such a way so that the corporation going forward is actually a non-share capital or a member-based corporation. So that's going to be tricky if you choose option 1. If you choose option 2 and you move OBCA, you're moving share capital to share capital, but there may be tax consequences in that case. And it is possible, although complicated, to maintain your non-profit status under the Income Tax Act as a share capital corporation. If you move instead to the Cooperative Corporations Act, there's a whole other set of requirements that are specific to the Cooperative Corporations Act that are not mirrored in either the ONCA or the OBCA or the OCA. So again, that would be a total reframing of the governance of the club. And in most cases, what I'm seeing is the Cooperative Corporations Act is not applicable or is not recommended for your golf clubs or your tennis clubs or your other kinds of social clubs that we're seeing that need to do the continuance. The tax consequences are not insignificant and are going to be very specific to the exact club. And so there isn't a one size fits all in this case, and tax advice from tax lawyers or from your accounting professionals are highly recommended at an early stage. A little bit about the two options here. So you can see on the slides now, you've got the ONCA and the OBCA columns. Obviously, the ONCA, you're now dealing with members instead of shareholders. Members under the ONCA have very similar rights to shareholders under the OBCA, so there will be some carryover of what those members' rights could be. In addition, Cliff and I have worked on a couple of these corporations, and we're finding ways to effectively mirror, to the extent possible, the shareholders' rights in the new non-share capital or member-based structure. So there are ways to take what rights the shareholders have under the old corporation and give them to those same individuals, but as members under the new corporation. But it's a fairly complicated technical procedure. You can see that the two little middle rows there deal with the tax consequences. Under the OBCA, as I said, it's likely that they may lose their tax exempt status. It's not clear. We actually just got a technical interpretation from the CRA, which says, among other things, that the corporate structure of a corporation, so whether it be share capital based or member based, doesn't necessarily dictate the tax status of the corporation. So whether it's a tax exempt NPO, nonprofit organization, or whether it's a taxable entity. Instead, it has to do with whether the corporation is operated for profit in any way, and whether the members or the shareholders have any ability to take that income. So there may be a way where you can operate a share capital corporation as a nonprofit NPO, but it's not obvious. So that's one of the other complicating factors in this case. When you're looking at clients, these social clubs, query whether they are in fact NPOs, so tax exempt, or whether they're tax paying entities. And the answer isn't clear or obvious in every case. It's a question of actually talking with the accountants, looking at the financial statements and determining whether they've been filing their taxes. They often are, but not exclusively. There are specific dissolution clauses as well that have to be considered if you're moving under the ONCA. So if you're going to be a member-based corporation, there are some new categories that need to be taken into account in terms of what goes into the articles of incorporation or continuance. So a little bit more on ONCA corporations. I've covered much of this already. So similar to shareholders, members have certain rights under the ONCA. This is the new category that I want to bring to your attention. So the ONCA brought into this new concept of a public benefit corporation. Most social clubs would not be public benefit corporations. A public benefit corporation is defined under the Act as being a charitable corporation. So that is usually registered with the CRA, although it's not a exact carryover in this case, or a non-charitable corporation that receives more than $10,000 in public money. The tricky part there was during COVID, government subsidies were considered public money. And so there were a number of non-charity corporations in Ontario that may have inadvertently switched over into the public benefit designation because of the government funding that they received. So that's something to take into account if these corporations are going to move into the ONCA legislation. We've covered the tax consequences. There's the potential tax consequences that need to be considered. If organizations want to be exempt under 149 sub 1L, which is your NPO exemption, they have to be operated for any purpose other than profit, and the members can't share in any of the income. If you're going to convert, you have to figure out how to deal with the shares. Importantly, very importantly, if a corporation is going to reacquire the shares from its shareholders, there could be fairly significant tax consequences for the shareholders. So this is not just about the tax consequences of the corporation, but the shareholders themselves, if they acquired these shares, at a low cost 30 years ago, for example, and if the corporation owns a significant amount of land, as golf clubs often do, those shares could be highly valued at this point, and that may have very significant consequences to the shareholders if they're moving from a social club to a non-share capital corporation. There are some mitigating options which we are actively looking at, but it is on a case-by-case basis. It is highly specific with respect to the facts. Okay, we'll cover that. If you move instead to an OBCA corporation, a little easier because, as I said, you're going share capital to share capital. Shareholders have certain rights under the OBCA. The dissolution is a little simpler if you've got shareholders. On dissolution, the shareholders are going to benefit from any of the remaining assets of the corporation. Like I said, the tax implications, however, are a little bit complicated. If it turns out that the corporation is moving from tax exempt under 149 sub 1L to a taxable entity, that is a taxable event that triggers a deemed disposition of all of the assets of the corporation. Now, if you think about it and you're moving tax exempt to taxed, and the disposition occurs immediately before the change of status, then there's not a significant amount of tax payable, at least in theory, because the corporation is at that time a tax exempt entity. However, there are some complicating factors if the corporation is subject to 149 sub 5, which is if they are running a dining and recreational facility, which many of these clubs are. So it's an important consideration there. Now, I imagine that these clubs, if they've been running as nonprofit organizations may want to continue to run as nonprofit organizations, likely meaning that the OBCA is not the right option, or we have to figure out how to maintain their nonprofit status under a share capital corporation, which will result or will require some updates to the share capital provisions. Failure to continue. So unlike non-share capital corporations who are transitioning to the ONCA, if they don't transition by October 2024, nothing dire will happen to them. We don't recommend it. There could be some unintended consequences with respect to the governance provisions that are in effect following October 2024, but they will not be dissolved. In this case, under this totally separate continuance regime, if these social clubs, which are still governed by the OCA, right, they haven't at all migrated to the ONCA, so still governed by the OCA, if they fail to choose a continuance option by October 2026, they will be deemed to have been dissolved the following day. That's it. They're out. However, there are some relieving provisions. They continue to exist in order to revive themselves effectively, and they have 20 years to get themselves back in order. So not ideal. Query whether there would be unintended consequences to the property. I don't know. But the consequences are much more significant and dire for these share capital social clubs. So what do clients need to do? Identify themselves. If you belong to a club, take a look, have a conversation with them. If you have any clients who are these social clubs, they are in a unique position here and they need to start taking action now. They need to start by identifying and locating existing shareholders. Not as easy as it sounds. Take a look at the financial statements, take a look at their books, figure out, parse through the various classes of shares and what their rights and entitlements are of each of the various classes of shares. And, and figure out what it is that we're going to have to deal with here. And then many, like for all of my continuance and transitions, get all of the constating documents together. Many of these are available online through the ministry. So if you have any clients that can't actually locate their governing documents, we can do a search and pull them all up, which is usually what we're going to do anyway, to make sure we have them all. And then what's different with these social clubs is we really need to take a look at their equity shareholdings and their assets and determine based on that the type of asset that they have, the types of shareholders that they have, the equity that the shareholders may have. All of those factors are going to suggest one option or another, or various stages of options. So there's not going to be one answer here, but it's going to depend on what the actual assets and shareholdings of the club are. Consult with accounting advisors regarding tax implications of continuance options. Do this early. Consider what the tax possibilities or implications are going to be of the various continuance options. And then take some time to create a process and timeline for the continuance. Like any continuance that you have to bring to your shareholders, you need to be mindful of the timelines of shareholder meetings. In addition, because whichever option is going forward is going to necessitate a fairly radical governance restructuring, the communications going out to the shareholders are going to have to be carefully thought through. And the implications for the shareholders, consider if you're moving from share capital to non-share capital and the shareholders may be facing capital gains, the communications to the shareholders need to be very carefully thought out given what the potential implications are for them. So here are the takeaways. It's complicated. It's specific to the organization. There are hundreds, I would say, of these clubs in Ontario. So it's not the thousands that we have for non-share capital corporations, but each one of these is going to be more complicated and take more time. And so you may not have many of them that come up in your practice or in your client base, but those that do are going to take a significant amount of energy there. So this shouldn't be something that we leave to the last minute. as I said, the consequences are a little more dire. And that's it for me.
Great. Thank you, Heather. And now over to Ian for our last presentation. And Jamie, if you could put up the slides for Ian, I appreciate Great. Thank you.
See that? Okay. Thanks, Jamie. Thanks, Lauren. So last and certainly hopefully least, because I think we are a bit over time here. I'll be talking about the Supreme Court of Canada's case Dean's Knight. It's the latest Supreme Court of Canada case discussing the general anti-avoidance rule. So a quick overview of the case. This company, Dean's Knight, had $90 million or so in non-capital losses. And in order to utilize those losses, they entered into a series of loss trading transactions, which we'll get into a little bit later. The minister denied those deductions. Subsection 111.5 limits the corporation's ability to use non-capital losses where a change in de jure control happens, an acquisition of control. And the Supreme Court of Canada applied the GAR to deny the losses, even though there was no actual acquisition of control here. So quickly going over the facts again, Dean's Knight had these unused non-capital losses. They entered into an investment agreement with an arm's length party called Matco, and Matco was tasked with finding an opportunity for Dean's Knight to use those losses. So here's a bit of the structure. You have Dean's Knight, a new parent corporation, New Forbes, is formed. Dean's Knight transfers the assets and liabilities up to New Forbes. Matco purchases a convertible debenture from Dean's Knight. So Matco then converts that debenture into shares, 35% of the votes and 79% of the equity. Then Dean's Knight goes through an IPO. Matco then purchases New Forbes shares. So Matco never actually acquires 50% of the votes in Dean's Knight. After this whole process, Dean's Knight has some income after the IPO and tries to utilize those losses and deduct them against the income. And the minister says this is an abusive anti-avoidance transaction and denies the losses. So the specific Income Tax Act provisions we're dealing with here are first, the acquisition of control rules under Section 111 and the general anti-avoidance rule under Section 245. So just a little bit about the acquisition of control rules. Generally, non-capital losses can be carried back 3 years and forward 20 years to be used against income earned by the corporation. Subsection 111.5 restricts the taxpayer's ability to carry over the losses where control of a corporation has been acquired by a single person or group of persons, unless the corporation continues the same or similar business. Control in this case is de jure control, so control in law, which generally we're looking at the majority of the votes to appoint the directors, the board of directors. And to look at that, we would generally look at the governing statute, share register, articles of incorporation, and any unanimous shareholders agreement. However, we would generally not be looking at external documents. And this is in contrast to de facto control, which, as the Income Tax Act defines, whenever the act uses the words controlled directly or indirectly in any manner whatever, This is de facto control in fact, which then allows us to look at all of the factors, including external documents. So in our case, the minister and Dean's Knight, they both agreed that there was no change in de jure control here. However, they argued on whether the GAR should apply. So the general test for the GAR is threefold. So first, there has to be a tax benefit. Second, the transaction giving rise to the tax benefit was an avoidance transaction, meaning that it was not a transaction undertaken primarily for a bona fide non-tax purpose. So the purpose test, it has to be for a business purpose. And three, the avoidance transaction was abusive. And to discuss whether or not a transaction is abusive, first we have to determine the object, spirit, and purpose of the relevant provision and determine whether the transactions in question frustrated the object, spirit, and purpose. So the Tax Court of Canada looked at this and said, okay, the object, spirit, and purpose of subsection 111.5 is to target the manipulation of losses of a corporation by a new person or group of persons through effective control over the corporation's actions. Now, where the Tax Court of Canada got this effective control, not really sure. It's not de jure control. It's not de facto control. But the tax court said, since Matco never got effective control over the corporation, the object, spirit, and purpose is not frustrated, and the GAR does not apply. So the Federal Court of Appeal looked at this and said, well, effective control isn't really a thing, so we're going to have to redefine the object, spirit, and purpose. So they defined it as to restrict the use of specified losses, including non-capital losses, if a person or group of persons has acquired actual control over the corporation's actions, whether by way of de jure control or otherwise. So the Federal Court of Appeal has made up another category of control, actual control. And they even say within the object, spirit, and purpose that it's de jure control or otherwise. So they've expanded the control as per the actual text of the provision. Since this investment agreement gives Matco actual control over Dean's Knight, part of the investment agreement is that Dean's Knight was not allowed to issue shares or make significant business decisions without Matco's approval. They had actual control over the corporation, and therefore the object, spirit, and purpose is frustrated, and the GAR applies to deny the losses. So the Supreme Court of Canada had a large majority, a 7-1 majority. First, they said, we agree there's a tax avoidance transaction here that resulted in a tax benefit. So now we have to look at whether it's abusive. So similar to what the lower courts did, they had to determine the object, spirit, and purpose and determine whether that was frustrated by the transactions in question. So the Supreme Court had a very interesting way of looking at it. They said we have to look at the underlying rationale of the provision, not just how is the provision actually constructed, what's the text of the provision, but why is the provision actually here? So the Supreme Court of Canada defines the object, spirit, and purpose of subsection 111.5 as to deny loss carryovers when there is a lack of continuity within the corporation as measured by both the identity of its controlling shareholders and its business activity. So the object, spirit, and purpose here doesn't actually refer to control at all, which is somewhat interesting. So what the court says is, even though there was no acquisition of de jure control, Matco achieved the functional equivalent of de jure control. So there was no continuity within the corporation because the taxpayers' assets, liabilities, and the shareholders were all fundamentally changed through this investment agreement. And the investment agreement restricted Dean's Knight's powers without consent from Matco. So Matco achieved the functional equivalent of de jure control, and the GAR applied. So before we conclude here, Justice Cote wrote a rather strongly worded dissent. She is of the opinion that the transactions are not abusive, where Parliament intended the acquisition to be only of de jure control. That's how they actually structured the text. And where a specific anti-avoidance rule is written in a specific way, Parliament should be thought to have left gaps intentionally, right? Because they made rules intentionally, one would think. However, what Justice Cote says the Supreme Court has done here is they've essentially given themselves the power to rewrite specific anti-avoidance rules in a way to expand the GAR. In this case, almost seemingly applying de facto control where de jure control is actually what's written. So our key takeaways here are, well, the Supreme Court of Canada says the Duke of Westminster, the principle that says that a taxpayer has the right to arrange their affairs so as to lower their tax, it's alive, but the GAR could apply at basically any time. So is it really alive? It's unclear. Secondly, the GAR may still apply even where Parliament has implemented specific anti-avoidance rules to prevent specific tax strategies, and the taxpayer has actually complied with the text of the rule. And third, and very much related to that, the Supreme Court could look beyond just what's written in the text, looking at the why rather than just the how, and according to Justice Cote, essentially rewrite the provision. And with that, I'll conclude. Thank you very much.
Okay, thank you, Ian. And we've come to the end of the webinar now. Thank you all for attending. We would be very interested in getting comments from you. Send us emails with suggestions for future webinars as well. The topics that you find of interest, would be happy to try to address them. Just a reminder, our website will have the recording and the presentations so that you can follow up and print out any of them that you wish. With that, we'll conclude today's webinar and look forward to seeing you at our next one. Thank you very much.